Hey guys, Jordan here. I hope you're doing well. As you can see, I'm actually shooting from my office today instead of my studio. And actually, the reason I'm doing that is because I keep getting phone calls from people who I think have some real misconceptions when it comes to what qualifies as a premarital asset and what doesn't. And I just thought I'd take a few minutes real quick to clear it up while it's on my mind. And here's what basically happens, right? The misconceptions tend to fall into basically two different groups. Misconceptions relating to, say, the house, and misconceptions relating to other kinds of money, other kinds of wealth. And the ones relating to the house are actually very common, right? It goes like this. Somebody will call me up and I'll be trying to go through, their premarital assets and what's subject to equitable distribution and not. And equitable distribution is just a fancy way of saying what is subject to being divided in the course of a divorce. And they'll say to me something like, well, yeah, I have a house, but I bought it ahead of the marriage, so that doesn't count. And it's like, well, wait a minute. I'll tell you if it doesn't count and tell me more about it. And what these people usually mean is that prior to the marriage, yes, they put a down payment on a house, and yes, they entered into a contract on the house, and yes, they have the house deeded in their name, okay, but the house wasn't paid off before the marriage. And so during the course of the marriage, they continued making payments. Well, a couple things about this. First of all, having the name on the deed is totally irrelevant. Whether, I see this all the time where people say, well, yeah, we have 3 cars, but they're all in my name. Well, so what? The issue is whether it was acquired during the marriage with marital funds, and if so, it doesn't really matter whose name it was in. I mean, the whole thing about the name really just has to do with creditors and who they can collect against. It has nothing really to do with what equitable distribution determines. But as far as the house being bought ahead of time, okay, understand that while maybe your down payment can be segregated from equitable distribution, that during the course of your marriage, you've been making payments on that house with marital money, and therefore marital equity is accruing, and marital equity is subject to equitable distribution. So here's an example just using easy numbers, okay? Let's say year one, somebody goes out and they buy a house for $100,000, which I know in New Jersey is impossible to do. It's just an easy number to work with, okay? They put 20% down, which is $20,000. And then for years 2 through 10 for the marriage, they're putting $3,000 down per year. Okay, so they put 3 times 9 is $27,000. Okay, well, when it comes time to get divorced, you can't just say, all right, well, I bought the house ahead of time, therefore it's not subject to division, because no, you put your down payment down ahead of time. You're still paying off the house. So maybe your 20% can be excluded, okay? But then the rest of the payments from years 2 through 10 are still going to be factored in when we figure out how much equity there is in the house and how to divide it. And what's probably just going to happen is we'll figure out you had 20% interest in the house in the beginning, okay? We're going to appraise the house now, see how much 20% equals now, segregate that part out, and the remaining equity is going to be split 50-50. That's how that's going to work. So this idea that you can just sort of bring the house into the marriage and then it's just yours outright is kind of flawed. And I'll tell you something else. There are some judges where they'll say, look, even your premarital equity shouldn't count because the wife, and we'll just use the wife as the example here, the wife during the course of the marriage has invested what's called sweat equity in the house. And there are some judges who will say, look, for every year of marriage, I'm going to give her another 8% of whatever equities in the house, whatever equity you guys have, or 10% or 12%, let's say 10%, so that after 10 years, whatever equity you brought in is completely evaporated. All right? So understand that just because you bring a house into a marriage doesn't mean that it's not subject to equitable distribution. Now, I had a case one time, this is another bit of an extreme, where there was a house, I think it was in Hillsborough, where you have a lot of houses that date back to the Revolutionary War, and this was such a house, and this one guy's family had owned the house, I'm not kidding, for over 200 years. And this woman had married the gentleman, and they were getting divorced after 8 years, and she wanted equity in the house. Well, that's a little bit different because, that's something that's been established, again, for 200 years. That's an extreme example. But she could still see her marital share increase, okay, simply by virtue of having been married and contributed to, household maintenance, that kind of thing. Because again, remember, family law is not a court of law, it's a court of equity. And so it's really just subject to whatever a judge thinks is fair. All right. And what's fair is very subjective. hence the term subject to. Which brings me to my second point, okay, money that's brought in. Now, the general principle with money that's brought into a marriage is that if that money starts getting commingled with marital assets, you can forget about it, all right? If you're going to bring money into a marriage, you better keep that money segregated in its own accounts. You better not be using it for marital expenses. You better not be putting marital money in it. It better just be separate and apart from the marriage. And then you have a shot of getting it held as a premarital asset, okay? The problem becomes people bring money into a marriage, they're putting their paychecks in that account, they're spending money in the account, now it's commingled and you can forget about it. Now it's a marital asset, okay? With retirement accounts, it can get kind of complicated because you will have contributed a certain amount before the marriage, okay? And then that amount will have grown. And what you have to do then is you really have to segregate that initial amount from the rest of it. Okay, which can be done. There are companies that do that, and that's not that much of a problem. Where it becomes more of a problem is trying to figure out how much it should have grown over the course of time, especially if there's been what's called active management of that money. In other words, it's one thing if you're just putting money into a brokerage account and it's some generic fund or whatever, some mutual fund, and all of the money is growing equivalently. It's quite something else if you're day trading money and then it's really difficult to see how much this amount would have grown relative to the rest of the amount. So it can get kind of complicated. But I'll give you another complication that people don't think about, okay? If you bring money into a marriage and the result of a divorce is that you're going to be leaving much better off than the person you're divorcing. So let's say a husband, because I've dealt with this situation. Let's say a husband brings about $50,000 into a marriage, which is segregated, okay? It's on its own, nobody doubts that. But for whatever reason, the marital assets, when they're divided, leave the wife in such a condition that she really can't care for herself or she can't enjoy the marital standard of living. But let's say it's a really extreme example where she's got some problems. She's going to be out in the street. It's a long-term marriage. She doesn't have any education. She's not going to be able to get on her feet, that sort of thing. And husband, yeah, he's not getting anything in the division of assets, but he still at least has $50,000 to walk away with. Well, the court might not exactly divide that asset up because, again, it's not going to be subject to division. But what the court can do is manipulate the spousal support award, in other words, the alimony award, to award more alimony to the wife, reflective of the fact that the husband can pay for it, reflective of the fact that the husband is in a superior financial position. And you could say, well, that's fair or that's not fair. That's irrelevant. I'm just saying that's what the court can do. That if you've got a situation where two people are going to exit a marriage, and husband, for example, is going to exit it in a vastly superior financial position to wife. The husband's going to be able to maintain the marital standard of living, and wife is not. And let's just add that, and let's say wife has a hardship, okay? Maybe it's a medical hardship. Maybe it's just the hardship is just she doesn't have any education, okay? If there's already going to be a spousal support component, don't be surprised if the judge factors into the spousal support component that the husband is in a vastly superior financial condition. So the court isn't actually touching the money that the husband brought into it, but the court is basically penalizing, I hate to use that word, but that's what it is, penalizing the husband for having the extra money and thereby increasing his spousal support obligation. So even though that's a premarital asset, the effect of that premarital asset is to increase spousal support. Again, doesn't matter if it's fair or not. I'm just telling you that's what you're subjecting yourself to, okay? So just keep that in mind, guys. If you're really concerned about this whole premarital asset situation, get a prenuptial agreement. Spell out what it is that you guys expect to enter the marriage with and what it is you expect to leave the marriage with if in case it decays. I did another video on that, so I'm not going to get too much into it now. If you haven't seen it, I certainly commend it to you. But that's really critical, okay? One of the great benefits of the prenuptial agreement is not just that it spells out what everyone's going to leave the marriage with, okay? It explains what everyone's bringing it into, so everybody's going into the marriage with eyes wide open. Again, go watch that video, that's separate. But this was just a brief primer on the concept of premarital assets. I'll do a video later on equitable distribution to kind of explain that in greater depth. But just for today's purposes, just understand if you're bringing the house in, you're probably not excluding the whole house. Okay, if you've entered into a contract, you made a down payment on a house ahead of time, that's one thing. But that doesn't mean that you now own the whole house such that it's not subject to equitable distribution. And the same thing is really true with retirement assets. Just because you had it ahead of time doesn't mean it's always entirely excludable, especially when it becomes commingled, and especially when one party is going to be leaving the marriage in a vastly inferior financial position to the other person. All right, if you have any more questions about this, please feel free to give me a call. I'll be happy to give you a free consultation. Just mention that you saw this video, and be happy to help you out. All right, guys, take care of yourselves.